Items for delivery of order. Item number 15, bail application 1579/2024.
Bail petition dismissed.
Item number 16, IS Civil 2072 of 2024.
IA dismiss. Yes.
Wait, please, Vilas. With the consent of the other side, I'd like to mention item number 19, my lord, matter fixed for hearing. In this matter, my lord, I'm filing my wakalatnama today itself. Can it be posted after 2 weeks?
On the pair being made by Mr.
My
Please,
lord,
Sharma.
my lord, any date may be fixed. I'm appearing on behalf of the respondent.
Learned Counsel for the
Appellants.
appellant. Recessal is the matter when?
Any date may be fixed, my
On
lord.
3rd October.
3rd of October.
Much.
May
Yes,
your lordship
yes.
indulge? Your lordship will recall this matter, item 14. was
Yes,
fixed last Thursday.
yes,
And because since I had stayed over because to do this matter, your lordship had said that I should mention it in the morning to be taken up at 12 today, my lords.
At
12 p.m. today, my lords.
today.
Yes, my lords. So the matter is it is pursuant to a Supreme Court order, my lord, that the matter has been sent back, and they've said that the matter should be disposed of with reasonable dispatch. I think
Okay.
12 o'clock, my lords. I am grateful.
May I please, your lordship? Lordship, may I play for listing of an IA for passing necessary orders for sending back the LCR, my lord?
When?
Tomorrow, my lord?
Tomorrow.
Please.
Please, your lordship. I'd like to mention item number 13, my lord, to concentrate on the other side. Kindly pass about the items, my lord.
You are for
I'm from petitioner.
Mr.
AK Das, my lord.
Learned Counsel appearing on behalf of Mr. Your name is there in the call list.
No, my lord, on behalf of SC Vishwas, my lord.
SC Vishwas. Learned conducting counsel for the appellant with consent from the other side. Price for listening the matter after
4 weeks, my lord.
4 weeks.
May I please, your lordship? Lordship, I beg to mention for a listing of a CRP IO for tomorrow.
When?
Tomorrow, lordship, it's an eviction matter.
Tomorrow.
Lordship,
Okay.
deeply obliged.
Please, lordship. I beg to mention for listing of a CRP IO for tomorrow.
When?
For tomorrow, lordship.
Tomorrow not possible.
Lordship, the matter is fixed for in the lower court on the 2nd of September.
Maybe next week any date.
Lordship, on Monday, then the matter is fixed on the in the lower court, lordship.
Maybe Monday.
On Monday, it is fixed.
Okay.
No, lordship.
No, tomorrow not possible.
They are on 31st.
34.
Yes, they will be court on 31st.
Obliged.
Your lordship, I beg to mention item number 7.
7.
Yes. With the consent from the other side, we want to adjourn the matter.
You are for respondent or appellant?
Your lordship.
Your good name?
S. Siddika.
Miss so-and-so, Learned Counsel. You are appearing on behalf of
A. Iqbal.
Mr. A. Iqbal, Learned Counsel for the appellant. With consent from the other side, press for listening the matter when?
Saturday or Tuesday, perhaps.
Saturday? Next Saturday not possible.
After
Tuesday. When? Next Tuesday. Tuesday.
3rd September.
May I please, your lordship? Lordship, I beg to mention for the listing of one RSA 5617, lordship, for tomorrow.
Tomorrow not possible. Any date next week.
31st.
Take a date from him.
On 2nd September.
2nd September. Your lordship, 3rd September.
Okay.
Deeply.
May I please, your lordship, mentioning for RSA, listing of RSA on Monday.
Monday we have lot of matters.
Tuesday.
6 September. Item as top of the list, item number 1.
May I plead your lordship? Lordship, I am apologize to say that this matter is led by my senior CK and Chaudhary. He has some difficulty to the lordship. So lordship kindly accommodate only for the lordship. With a very.
Did you inform the other side?
Yes, Lordship, yesterday we have informed
What is your name?
our Kakotik.
Ms. Sunso, Learned Counsel appearing on behalf of Mr. K. M. Chaudhary, Learned Conducting Counsel for the appellant with consent from the other side, press for listing the matter. No, therefore adjourning the matter for the day. Pair allowed, recessal is the matter when
24th September.
Must oblige.
Number 2 as covered the list.
So I have actually last date, some DW cross examination are not available in the record. আপোনালোকে চাইছিলে নেকি এইটো আমাৰ তাত আছে আপোনালোকৰ তাত আছে কিন্তু কোৰ্টত নাছিলে এইকাৰণে
Your lordship, they have to establish a case on their deposition, not on our deposition.
এইটো বেলেগ কথা that is a separate matter but
So it is there in the record. I have annexed it, page 161 is there, your lordship. Cross is there.
you don't want your cross examination in the record that
No,
means
it is there,
you
it
have
is
no
there.
evidence then
It is there. How it will be this? It is there already, your it starts from page 161.
so both parties has to be accepted that evidence yes it is not available in the record আর আপনাদের এবার রেকর্ড চাই লোক আছে যদি ওখান পর পাই যদি
Page 160, we have the cross of this, it is there already. 161 also.
DW1 is there.
yes but it is not in the record that's for when we have started to read evidences these are not in the original record original court record that was given from the lower court their cross examinations of DWs are not present.
You have certified copies?
Actually, it was examined before commissioner. So commissioner or at the time of after the cross examination of completion of evidence, they handed over us the photocopy of that evidence. That is available with both the parties, I think. Nowadays, therefore, certificate copies are rarely obtained. So we have got immediately the photocopies of that evidence.
You can rely on.
If both the parties accept, then it can be evidence, and a court can also record about the same because that it is not available. So court has to pass an order.
Disputing against the translated.
No, it will be so. Mane court has to pass an order that regarding this. I think if court thinks proper, because it is to be considered. It is in the not record. So in this regard, order.
If the photocopy is accepted, we cannot take it.
No, if the other side has not disputed the cross-examination,
Your lordship,
they have not disputed.
we have no objection. But if court thinks that without in the record of the court, this can be accepted, we have no objection.
Can we take
No, if there is no dispute from any of the parties, then where is the question?
We have no objection.
Court has to
It
be,
is your case, not my case.
court has to be passed an order
Regarding,
regarding that this or the cross examination part is not available.
no, I have not checked the record.
Your lordship, last date, your lordship has checked the same. Thereafter,
No, only in their absence, you have submitted that such and such documents are not available in the record.
not documents. But
I have not checked it.
So say a few minutes, maybe even time being, maybe question is coming.
Okay. After some time.
Sometime, yes.
For bail hearing, item 3.
May I please, your lordship. Lordship matter may be passed over for time being, lordship. My senior counsel engaging in another good law.
Who is your senior counsel?
Service. KK Mohanpuri. Yes, service completed, my lord. We have received our copy, my lord.
Service completed, but whether respondent number 2 is represented?
My lord, I have received today, my lord. No, this is not, MES can be not yet appointed, my lord.
Not yet appointed.
Not yet appointed.
So if nobody entered appearance on behalf of the respondent number 2, we have to engage on legal aid counsel
My lord,
to represent her case.
my lord. Lordship,
So,
matter may pass over for time being, lordship. My senior counsel is.
No, if your senior remain present also,
Also.
then also we cannot dispose of the petition today.
Oh, my lord. Lordship.
Heard, Mr. Your good name?
A. Soikia.
Learned counsel for the accused, and also heard Mr. B. Sharma, learned additional BP for the split respondent. Mr. Sharma, learned additional PP, has produced a report from the officer in search of jurisdictional PS in respect of service of notice upon respondent number 2. But respondent number 2 remain unrepresented today. Therefore, this court is inclined to engage. Engage Advocate Pavitra Soikia as the legal aid counsel to represent the respondent number 2. Rest shall list the matter tomorrow.
Lordship.
Tomorrow. And reflect the name of Mr. Pavitra Soikia in the cause list. And furnish the relevant papers well in advance to him. List the matter tomorrow.
Party. Oblige, your lordship.
Item 17.
May I please?
Yes.
Starting with the legal counsel.
The matter may can be taken after some time, your lordship.
After some time.
Number 4.
May I please, your lordship? My senior is on leg, so kindly pass over for timing, your lordship.
Next second.
Item number 5 orders.
It pleases your lordship. Lordship, with regard to service, it has been completed. Which is reflected in the order dated 26/6/24.
So we will list the matter for hearing then.
Yes, lordship, but there is some urgency, so lordship may fix a date, lordship.
Heard, Mr. Your good name?
A Decca, lordship.
A. Decker, learned counsel for the petitioner. Mr. Decker, referring to the order dated 26/6/2024, submits that service has already been completed. The matter may be listed for hearing. Accordingly, it is provided that registrar shall list the matter on
12th of September.
12 for hearing.
Much.
Number 6. Item number 6.
As per office note, malab dated 27/8, malab, service was yet not received, malab. As well as malab, scan copy of the LCR also not received.
Heard, Mr. Patgiri, learned counsel for the petitioner. Office note dated 27/8/2024 indicates that service report in respect of the respondents are still awaited. And the scanned copy of the LCR has also not been received. Accordingly, it is provided that SSL issue reminder to the learned trial court for transmitting the record without further delay. And list the matter when?
After 15 days, madam.
After
15 days, madam.
15 days.
Okay.
After
Because
2 weeks, awaiting service report upon the respondent.
That may be fixed, madam.
Immediately after receiving the record from the trial court.
If the cross examination only held, madam, 10, madam,
When the next date is fixed.
tomorrow is for NO, my lord. And next date, madam, thereafter, madam, cross examination.
Data the DT.
On 20 September.
Obliged.
Item 18.
On appeal council is on the exam court number 5, the matter will be taken up for some time. Obliged.
For hearing, item number 8.
My lord, item number 18, my lord. The councils of both the sides are on legs at court number 7, my lord. Item will be taken up after some time.
Item number 18.
18.
Just time me on.
Nothing.
For hearing, item 8.
I'm appealing for respondent, madam.
Who is for the appellant?
D. Burwa was there, Diganto Burwa.
None appears for the appellant on call, however, Mr.
TK Bhuya, madam.
T.K. Bhuya, learned counsel for the respondent present. List the matter when?
Next week, my lord, Thursday.
After vacation, after
5th of September, my lord.
5th of September.
Or my lord, 12th.
So after vacation,
Some urgency is there, my lord. Therefore, my lord.
pardon? Urgency.
Some urgency is there, my lord.
On 3rd October.
3rd October. Grateful, my lord.
Item number 9.
My lord, my senior is coming. Have you taken up?
Item 10.
Please, your lordship. This case, your honor, lordship, we have been newly engaged in this case. So we need some time to collect the brief and also.
You for the appellant?
Lordship. My lord, we are the degree holder, my lord. And they have not filed any evidence also in the court below. And this matter is relating to specific relief act. Specific relief act. The sale deed has not been executed. They are holding my money from 2012. So in that case, my lord, last occasion, I accommodated them, my lord.
Lordship, day before yesterday, they instructed to appear this matter. So we need some time, Lordship.
When?
The date may be given then in that case.
After 4 weeks, Lordship.
After Puja vacation, then.
After vacation.
For their convenience.
Lordship.
Heard, Mr. Your good name?
A Deka.
A. Deka, learned counsel. And also heard Mr. Borua, learned counsel for the respondent. Mr. Decker, learned counsel for the appellant submits that he has newly been engaged, and therefore he prays that the matter may be listed after the vacation, immediately after reopening of the vacation.
Can it be on 24th of October? Madam? The date, 24th of October.
Okay. Is it a working day?
Yes, madam. It's a, I've seen that.
Okay, okay.
Hearing day, my.
Item 11.
Mayor, please allow me. Lord, in this case, my lord, on 22/2019, my lord, a substantial question of law was framed. My lord, whether the trial court erred in law in past expiry judgment and decree, my lord. What happened, my lord? Suit was filed against me, my lord. I am the defendant appellant, my lord, hearing. But the suit was decided expired. Thereafter, I have filed an application for setting aside the expiry decree before the learned trial court, my lord. Their application was not accepted, my lord. Thereafter, my lord, I have filed an application before this honorable court as a CRP, my lord. The CRP was dismissed, seeking a direction to accept my application under Order 9 Rule 13, my lord. Thereafter, I handed over the brief to my learned engaged counsel to file an appeal before against that, my lord, expired judgment. The appeal was not filed. I have a lodged complaint in the Bar Association, my lord, against that particular council, my lord, but nothing was happened, my lord. In that process, my lord, the delay amounting to, my lord, 5,000 days in filing this, my lord, this second appeal. So, my lord, may I suggest one more substantial question of law, my lord? Because, my lord, this appeal has been filed against the application miscase number 34/17. Your lordship will find at page 32, my lord.
So that delay has already been condoned.
Not condoned, my lord. Before the learned first appellate court, my lord. Against that order, this second appeal has been filed. On merit, my lord, this second appeal is not filed, my lord. Along with the title appeal, my lord, I have filed an application under Section 5 of the Limitation Act, my lord. That was dismissed, my lord. Accordingly, my lord, the title appeal automatically dismissed, my lord. May I suggest one more substantial question of law, my lord?
You were referring to page number?
Page number 32, my lord. This is the impugn order, my lord. May I read, my lord? The learned counsel for the petitioner appellant is present and the respondent opposite party is represented by his learned counsel. The petitioner appellant has filed a petition number so and so supported by an affidavit under Section 5 of the Limitation Act, praying for condoning the delay of 5,352 days in filing the title appeal. The brief fact of the petition is that the appellant filed this appeal against the ex parte judgment and decree dated 16/2/2002 entitled suit number 63/99 passed by the learned civil judge senior division number 1 Borpeta, and thereafter the title execution case number 2/2003 was also ex parte decreed on 3/6/2006. To set aside such ex parte decisions, the applicant filed an application under Order 9 Rule 13 of the CPC before the trial court along with the condonation petition, but those applications were neither accepted nor registered, for which he filed a civil revision petition bearing CRP number 311/06 before the Honorable Guwahati High Court, praying for a direction to the learned trial court for register his applications and consider the same. But the civil revision was also rejected on 15/9/2006. He engaged advocate namely so and so to file title appeal against the said ex parte decree and paid the legal fees and handed over the entire original record along with the judgment and decree. The engaged advocate did not file any appeal, who falsely said to him that the proceeding of appeal is going on. Being an illiterate person, he believed that the appeal is filed and the proceeding is going on. But while he came to know that the respondent started to develop the land, he went to the advocate to know about the status of the appeal, and he was said that no appeal was filed. He submitted a complaint before the Bar Association against the advocate to return the file of the original copies, but the complaint is pending till now, and the advocate also has not returned the original copies to him. Now he has filed this appeal for setting aside the ex parte order and application for condoning the delay in filing this appeal. The ex parte impugned judgment and decree was passed on 16/2/2002, and the ex parte order in title execution was passed in 3/6/2006. Thereafter, he filed an application for cancellation of those ex parte orders which were not registered by the trial court. So he filed a civil division petition bearing a CRP number 311/06 on 12/9/2006 for direction to re-register this application, but the same was rejected on 15/9/2006. Thereafter, his engaged advocate misleading him in filing the title appeal, who falsely said that the appeal is filed and the same is proceeding. Now he came to know that no appeal is filed. His complaint against the advocate is pending till now. Hence, he has no negligence for delay or a long period for filing this application. The delay of 5,352 days may be condoned. The applicant begs to submit that if this court is not pleased to condone the delay in filing the appeal, he will suffer seriously. Hence, prays for admit the application by condoning delay of 5,352 days in filing the title appeal and or pass any other orders and as deemed fit and proper. As against the above, the opposite party respondent has filed a written objection stating that the present petition of the petitioner is not maintainable in the eye of law under Section 5 of the Limitation Act to condone the delay of 5,352 days to file the appeal against the ex parte judgment dated 16/2/2002 passed by the learned civil judge Junior Division Number 1 Borpeta in connection with title suit number 63/99. Petitioner was doing for the last 50 years, and thereby the petition is required to be dismissed. As a matter of fact, nothing has been mentioned in the petition of petitioner as to who did not give proper instruction or as to who had possibly played the mischief.
You have missed one page.
My lord. Oh, my lord,
Written
one
another
page
page.
has been skipped, my lord.
Hmm.
Page 34, my lord. I am
Hmm.
reading, my lord.
Yes.
Was said that no appeal was filed,
No, where is the beginning of that sentence?
my lord.
The sentence started from the word was.
Well, if I read the last line of the page 33, Borpeta in connection with title suit number 63/99.
Hmm.
Probably, my lord, one page is missing, my lord.
Hmm?
One page is missing. One page is missing, probably, my lord.
You check the record. We will take it up after some time then.
My lord. Add two, my lord.
Okay, no
Right.
problem.
I'll check it.
Item 12.
The second appeal is arising out of the order passed by the Current Law Appellate Court, whereby the application which was filed with regard to the objection to the execution of the decree. Now, what has happened in this case, Lordship, the predecessor of the present appellant, she filed an application suit for ejectment of the tenant. So the tenant accordingly at the time of submitting the written statement admitted the fact there is some default in payment of rent. So accordingly, the trial court decreed the suit based on the admission of fact. Now, what has happened after the decree was put to execution, the time of executing the decree or vacating the tenanted premises, the present respondent filed an application under Order 21 Rule 97, stating that he is in actual possession of the property. So that in that particular application, we have submitted the present appellant has submitted the objection that there was no tenancy with regard to the respondent or the objector. The lower, the executing court accordingly rejected the application of the respondent hearing or the objector. Which was
Other
filed-
side?
On the other side, Lordship, the name has been shown, but repeatedly nobody has arrived. In the last occasion also the observation is there. The Honorable Court has passed a observation, it's an observation of the Honorable Court. On various occasions, the matter has been listed. The counsel whose name has been shown, possibly she is not appearing. The matter is of
Okay,
School
who is
matter.
the other side? D Shalkya.
Yes.
Item number 12. 12. Yes, yeah. Basta क्या उधर वो चली हुआ नहीं फिर हुआ नहीं ना होता itu bisnya satu bisa Jesse Jesse gora set up so wait for some time let him complete the concept.
Contact number is there, Lordship. Contact number is there.
You will check.
Priming item 2.
On last occasion, Lordship, we have made a submission regarding the evidence of the DW. And at the time of verification of the record in lower court record, we have not found the evidence cross-examination part of the DW. And in the LCR, it is not available. And that is why the trial court has said there is no evidence in the judgment itself. Lordship will find the last portion that there is no evidence of the defense witness. Lordship will find at the plain judgment itself. Lordship will find at page 27.
Yes.
Lordship will find defendant witness Soben Miki. Only Soben Miki. He has examined one witness, two witnesses that has been recorded because there is no record in the HCL.
Soben Miki is not my witness. I have told.
No, I am not saying Soben Miki.
Not my
Their
witness.
witness. Appellant witness.
No, that's not. He is not our witness.
I am not saying Soben Miki your witness. I am saying your witness has not been recorded in the order sheet, in the last portion of the appendix. There is nothing in the record that there is a defense witness. Because if he is not cross-examined, that cannot be considered as evidence. That is why trial court has held there is no evidence. If Lordship decide this matter that there is no evidence from defense side, then I have no objection. I will argue the case. There is no defense evidence because Lordship, there is no evidence in the trial court record. In the LCR, there is no evidence.
So whether any order was passed by the trial court
Regarding,
that there is no defense evidence?
in the judgment itself, it is reflected. They have make a submission before the honorable court that their evidence was not discussed by the trial court in the judgment.
Which part of the judgment it is reflected?
Last portion, Lordship will find in last portion of the judgment. Defendant witness. Page 27. Defendant witness, Dilul Soben Mikir. Appellant witness was not mentioned because there is no evidence.
Here it is mentioned as DW3 in page number
DW3 is
27.
not their witness. DW3 is not their witness.
DW3 is Subhen Miki, he is the counsel for Subhen Miki. There are other different defendants also.
Defendant
Beside
number 1.
them, there is other defendant.
Yes, Mr. Sodore, is it a correct position that no witnesses have been examined on your behalf?
The witness has been examined here. We have 3 witnesses.
That is why I am
Then
saying.
we have submitted the record is there, we have submitted.
They can verify the record. We have verified the record. There is no evidence.
Okay, there will be no evidence, because we have.
That is why court has recorded no evidence. LCR, LCR will Lordship will verify the LCR.
Yeah, your lordship.
No, this is your case. You
Yeah,
check
they have
it and verify it from the record of whether it is available or not available.
We have verified, Lordship. Last occasion we have pointed out. Today also we pointed out. LCR से क्या लगे?
Then he was finding suit. It is a boundary to prove his own case. And he cannot.
আমার কথা তো কোন যেটা বলে।
He cannot declare. As per I have cited the ruling also. So this 1998 SC. 1998 SC, Ramdas, Orthar, Talim Ahmed, page number, I have only said it. Page number 719. Under this specific letter. Declaration of title to issue property. Witness in defendant's claim for title to property. They cannot establish the side. So plaintiff is not entitled to get relief of title if such declare, if such title not be established by the convincing evidence. Where the case your lordship. Plaintiff has failed to establish right and title interest. If your lordship go to the case number.
No, you check it whether the evidence of your witnesses are available on the record or not.
Yeah, we have cited, we have filed this evidence across.
We have filed it,
And then
we have translated copy of
we have
it.
translated.
It's there in the record.
But those are not certified copies, perhaps. Those are Xerox copies, which are available on the record.
Oh, with the, because Xerox copy, that's it.
আলুটা LCR
the
টা
original
check করে
has
দাও,
come.
আপনার ওখানে হয়েছিল।
Even Xerox copy also comes from the original. Because we are not disputing the Xerox copies. They are also not disputing Xerox copies. So it can go ahead because as secondary evidence you are not.
I have no objection to that effect. If Lordship may record that there is no document in the LCR regarding the witnesses. That may be recorded. Then I will argue this.
Certified.
But they can show the record, Lordship.
That is their case, not my case. They have to, they are the plaintiff. They are putting the burden, entire burden to us.
We have no
They
objection
want
to
to
that.
prove their guy through us. That cannot be done, your lordship. They have to, their case should stand on their own leg. Not on the deposition. They cannot prove the case on deposition of the defendant, your lordship. They are plaintiff, they have admitted they don't have possession, they don't have trial, nothing is there. They have sidetracked that they come to this thing. They are not reflecting the real issue of the matter, your lordship, which I have argued, your lordship. They are sidetracking the whole issue, going to a different lane. And
PW, that those translated copies are there, your page 161, these are there, cross are there. How can you say it's not there? Solve it. There, your honor. Whether their certified copy or their cross is also there, that also I don't know whether they are there. Their evidence, whether certified copy is available or not. No, that's the original.
Original record, I'm saying.
Original, I'm saying original certificate, you are talking about certified copy. Whether you certified copy of.
We are not saying about certified copy or original copy. We are saying LCR, there is no evidence of the defensiveness of the appellant. That is my submission. I'm not submitting anything.
Okay.
আমাকে টাইপ কপি দিছি ইয়াতে টাইপ কপি দিছে তারে অরিজিনালটো দিয়া নাই
Good.
ইয়াতে টাইপ কপি দিছে কিন্তু টাইপ কপি কি হবে টাইপ দিছে কি দিয়া নাই সবসময় এখানে কিছু তো
You'll also fix it day after tomorrow.
Pardon?
Fix it day after tomorrow, Saturday.
Day after tomorrow. Okay.
Let's say day after tomorrow, I have to outside. Let's say. I have to go to
Saturday is the. We are finishing up.
My case has been fixed on Saturday. Let's say.
Then let us have
Other
it
court
today.
Gulaghar. Next week.
Let us finish the argument, your lord. Let us finish the argument on that.
ঠিক আছে যদি এভিডেন্স নাই দিব
Let's see, may record in my submission that there is no evidence on the part of the.
No, without a
record.
verification and without admitting by them, how can I record it?
Let's see, my submission.
No.
My submission, not either admission. My submission will be recorded that from the LCR, there is no defense witnesses from the appellant side.
May I please, your lordship? Only one mistake. There are so many judgments. I have always said. What is? Suppose the defendant has not adduced evidence. Is it mean that defendant should write the interest? Is it mean? Suppose defendant has no evidence at all. Suppose.
No, on the other day, there was a submission on part of Mr. Soudhuri that the matter may be remanded back for non-consideration of the evidence of the defense with defendant's witnesses. So to appreciate that submission, we have to verify the record, whether it is available or not. You check the record. If it is available, then all right. If it is not available, then we have to call for it from the concerned court.
Time, check the record.
Okay.
Timing item 17, then hearing.
I'm sorry, my lord, I was on late, my lord. Report 7. On the
You are for respondent?
respondent but two, my lord.
Two, yes.
May I please, Lordship?
Yes.
Lordship, FIR at page 15, Lord. Basically, FIR was lost against two persons, Lord. One, Jannat Islam, and one Nekibur Islam. As part of FIR, Lord, Jannat Islam impregnated the granddaughter of the informant, and subsequently he took her, the victim girl, to Gorsiga and aborted her.
Yes, my lord.
Yes.
Page 4, my lord.
The other day, Mr. Sen has pointed out something.
Regarding my lord, the record. So far,
Regarding?
last of it, my record was called for. So far, my brother's submission was that without record, my lord, the honorable court has power to admit the matter. That was the submission. So far,
Without record.
Record was called for. Accordingly, you lordship has freed this matter for admission. Earlier, my lord, initially, my lord, record was called for. Notice was issued. Record was called for.
And subsequently, when the matter has been listed, my lord, you will also follow the same.
Maybe, but notice was issued and the record was also called for. But that is only after admission.
But that was the submission made by my learned brother.
Matter is yet
After
to be
submission,
admitted.
record would be, ought to have been made a call for. That was, it was the submission of my brother.
Yes. The second level has to be admitted only on substantial question of law.
Yes. Page 4, the substantial question of which I have formulated. Basically.
Yes, Mr. Sen, what was your submission on the other day?
My lord, first of all, my lord, the LCR was called for, my lord, without formulating the substantial question of.
Yes.
That is why, my lord, I objected on the other day. That first of all, my lord, your lordship has to formulate the substantial question of law, if at all is there in the case, my lord. Now, in the instant case, my lord, your lordship will find, my lord, the plaintiff filed the suit. We are the defendant, my lord, in the suit. The plaintiff and the defendant are two brothers here. They have plaintiff, my lord, filed the suit against his brother. Brother died, my lord, against his legal heirs now, who have been substituted in the suit during pendency of the suit, my lord. The brother died. Now the suit, my lord, suit land, he says that he was jointly possession in the suit land, my lord. He has right over the suit land, and accordingly, my lord, he has a right. I mean to say the preferential right under section 22 of the Hindu Succession Act, my lord, that before purchasing to third party, before selling my share to third party, my lord, I will have to offer my brother first. That is section 22 of, my lord, the
Succession Act.
Section Hindu Succession Act. My lord. Now, in this case, my lord, your lordship will find that the land between the brothers, my lord, has already been partitioned. It has been partitioned by way of partition deed, my lord, which was duly registered in the office of sub-registered Karimganj, my lord. And after partition, my lord, they are separately, my lord, possessing the land in each of their share. Thereafter, my lord, the land which has been partitioned, the predecessor of the defendant, my lord, my husband and my daughters, my lord, and the daughters of the deceased, my lord, they have now sold the land, my lord, to defendant number 5, 6, and 7 by the after partition of the suit land. Now, both the learned courts below, my lord, the trial court as well as the appellate court, my lord, has held that since the land has been partitioned all together, my lord, in between the brothers during the lifetime of the defendant, as well as, my lord, the plaintiff, and it has been duly registered. My lord, the section 22 in the instant case is not applicable, and accordingly, both the court below has held, my lord, that the plaintiff has no right, my lord, and accordingly, the suit filed by the plaintiff has been dismissed. Now, the evidence and the materials on record goes to show, my lord, that, my lord, they are the owners of the land. They have partitioned the land. After partition, my lord, the defendant has sold their part of land, their share of land to defendant number 6, 7, and 8, 5, 6, and Now they challenge the say to defendant number 5, 6, and 7. Saying what, my lord? Saying that the defendant ought to have offered him because of section 22 of the, my lord, Hindu Succession Act. But both the learned courts below, my lord, learned trial judge as well as, my lord, the learned appellate court has said, my lord, categorically, after appreciating the evidence and materials on record, my lord, that the land has been partitioned. And after having been partitioned, my lord, the application, the right of under my lord, section 22 is not applicable in that case. Therefore, both the suit filed by the my lord, filed by the plaintiff has been dismissed by both the courts below, my lord. Therefore, they have no case, my lord, at all. My lord, if your lordship kindly sees the substantial question of law at page 4, my lord, these are not substantial questions of law. My lord, they will have to show as to the perversity, my lord. What is the perversity? Merely saying that the judgment is perverse is not due, my lord, is not enough. My lord, my learned friend will have to show that this is the evidence, my lord, which has not been appreciated or overlooked by the learned appellate court or, my lord, learned trial court. This has not been, my lord, simply saying that the impugned judgment is perverse, my lord, cannot be a substantial question of law. My lord, he must satisfy this honorable court that this is my evidence which has been ignored by the learned courts below. That is not there, my lord. Number 2, my lord, your lordship will see, my lord, the judgment that has been reflected, my lord. Also, I have pointed out, my lord, both the judgments of the, my lord, the apex court as well as this honorable court has said that if the land is partitioned amongst the brothers, then, my lord, he cannot claim the preferential right under section 22 of the, my lord, the Hindu Succession Act. In the
So where is those judgments?
my lord, these judgments, my lord, it is already indicated in the my lord, trial court judgment as well as, my lord, the learned court judgment. Your lordship kindly see, my lord, the trial court judgment at page . At page 37, your lordship kindly see. Page 37, it is reflected, my lord. AIR 2000, my lord, Guwahati 117. Krishna Pada Rai and another versus Parimal Chandra Saha and another. Page 37, my lord, of the memo of appeal.
No, well, where is the judgment of Supreme Court?
My lord, it is reflected, my lord, your lordship will find at page 64, my lord.
There's 61.
61 is something else, my lord. 64 is relevant for our case. 61 says something else, my lord. It is says that you plaintiff cannot take, my lord, double two stand. 64, my lord, it says Sunanda Singh versus Soni Sahi reported in 2023-5 CK 225.
Patna High Court.
This is Patna High Court. Patna High Court, yes, my lord. Here also says, my lord, and 61 and 58, my lord. I'm sorry, 61, my lord, Kailash Rai versus Jairam Rai and others. 1973, my lord. AIR 893.
No, that is in respect of possession.
Possession, my lord. And if the possession, my lord, here it is says, my lord, if the possession, my lord, is partitioned by way of partition deed. And the law itself says, my lord, section 22, Hindu Succession Act there. And AIR 2000 Guwahati, Guwahati 1178 says, my lord, Section 22 of Hindu Succession Act envisages that the right to preemption, those cases where the partition of the property is incomplete. Such right cannot be claimed where the property has already been partitioned. And at page 37. Page 37, my lord. AIR, has your lordship got it, my lord? AIR 2000 Guwahati 117, Krishna Pada Rai and another versus Parimal Chandra Saha and another. That apparently under section 22 of the Hindu Succession Act, that is their case, my lord, section 22, emphasize that the right of preemption, those cases where partition of property is incomplete. Well, where the partition is not done. Incomplete means where the partition is not done. Here, my lord, your lordship will find exhibit number 5 is the deed of partition, which has been exhibited in the case, which has been admitted by the plaintiff as well as the defendant. Yes, the land has been partitioned, and we are possessing the land after partition, my lord, with specific boundary, each of our share. Therefore, this section 22, my lord, at all, my lord, is not, my lord, attributable or applicable in the same case. And my lord, this section also, my lord, it is clear, section 22. Your lordship kindly see, my lord, section 22 of the Hindu Succession Act. Section 22.
Yes.
Where after commencement of this act, interest in any immovable property of an intestate or in any business carried out by him or her, whether solely or in conjunction with others, devolve upon 2 or more years specified in class 1 of the schedule, and any one of such years proposes to transfer his or her interest of property or business, the other here shall have a preferential right to acquire the interest proposed to be transferred. Then, my lord, subclause 2, in consideration for which any interest in the property of the deceased may be transferred under this section shall be, in absence of agreement between the parties, be determined by the court on application being made to it in this behalf, and in any person opposing to acquire, the interest is not willing to acquire it for the consideration so determined. Such person shall be liable to pay the cost or incident of it. If there are 2 more specified in class in proposing to acquire any interest under this section, the heirs who offers the highest consideration for the transfer shall be prepared. Now, this section 22 has been, my lord, interpreted by this honorable court in the judgment, my lord, which I have already indicated, my lord, in page 37 of the memo of appeal, my lord, AIR 2000 Guwahati 117, which says, my lord, that if partition is, my lord, complete, if a partition is done, then, my lord, the right of preferential right under section 22 of Hindu Succession Act is not applicable at all. Therefore, the suit filed by the plaintiff, my lord, is absolutely, my lord, unsustainable, and accordingly, my lord, both the courts below dismiss their suit, my lord, the suit as well as the appeal, my lord. Therefore, there is no substantial question of law remains, my lord, to formulate and, my lord, to further adjudicate the case. Case is not required to be admitted, my lord. It should be dismissed, my lord, at the admission stage itself, my lord. That is my recommendation. Because the evidence and materials, my lord, if your lordship, my lord, goes through the, my lord, the appellate court judgment, my lord, there is no infirmity and illegality, or rather, my lord, error committed by the, my lord, learned trial judge, as well as, my lord, the learned appellate court. If your lordship, my lord, if it does not inspire your lordship confidence, my lord, your lordship may call for the record, but, my lord, ultimately, my lord, they have no case at all.
No, no,
Because prima facie, my lord, your lordship will find that
no, unless we admit appeal.
yes, my lord, that is my respectful submission.
Why should we call for the record?
Yes, my lord, absolutely, my lord. And the judgment, my lord, issue number 3, my lord, at page 6 of the trial court judgment, my lord. My lord, page number 32.
Yes.
Issue number 3, my lord. Whether the suit land was already partitioned between the co-sharers or remained joint property of the plaintiff and the predecessor of the defendant number 1 to 4. As a relevant issue, as this is relevant issue, PW1 has stated in his evidence that the plaintiff is a permanent resident of the address given above, and he was bona fide owner and possessor of the suit schedule land and others as youth right holders under the original landlord Ellen Chalmers and 3 others. The predecessor of the defendant number 1 to 4, late Subroto Das Chaudhary, who was the elder brother of the plaintiff and was an employee of the state fed, used to live outside his permanent homestead with his family members. The suit land and its adjacent land covered by tag number so and so. The mother of the plaintiff was the original tenant of the landlord Ellen Chalmers, and she transferred her land in favor of the plaintiff and his brothers Subroto Das Chaudhary by registered deed number so and so, dated so and so. Since then, they are in peaceful possession of the land along with their oral tenancy and under the land Ellen Chalmers. None of the defendant interrupted them in their possession. Late Subroto Das Chaudhary had no male child. The defendant number 2, 3, and 4 are his daughters who married and have been living in their respective matrimonial houses. Only the daughter have been living with her husband in the residence of her mother at Hailakandi town, ward number so and so. The defendant number 1 was never in possession of the suit land. It was always under the possession of the plaintiff. She lives at Hailakandi town with her husband, who died there. Her husband, by registered deed number so and so, gifted some land to her, but it was never acted upon. It was simply a paper transaction. She was not given possession of it till the death of the donor. During settlement operation, tenancy Khatiyan number so and so was issued in the name of the plaintiff and dated so and so under Assam Temporary Settled Areas Tenancy Act, including some of other land and a portion of the suit land which is a part and parcel of the jute right under the occupation of the brothers, and consequently White award case number so and so additional deputy commissioner so and so allowed ownership right of the plaintiff in respect of 3 biga 15 katas of land covered by the number so and so, pattern number so and so. The plaintiff in his and his brother executed a partition deed. This is important, you know. Executed a partition deed number 77 dated 14/2/1991 for their jute right, and since no patta was issued in this name, so the deed was not acted upon. Thereafter, the period patta was issued in the name of the plaintiff. The predecessor of the defendant number 1 to 4 purchased part and parcel of the suit land from the plaintiff by registered deed number so and so, but the same was remained under joint possession of the parties. The suit land remained under joint possession of the plaintiff and the defendants number 1 to 4 in the changed circumstances. On the death of the Subrato Das Chaudhary, his legal heir, namely the defendant number 1 to 4, inherited the same as co-sharer. It is evidentiating that the aforesaid fact, the exhibit number 2, certified copy of gift deed dated so and so, Katiyan number so and so, mark 4, certified copy of AOR exhibit 5, partition deed number so and so, dated so and so, exhibit 6, certified copy of deed number so and so, exhibit 7, certified copy of the sale deed number so and so, exhibit 8, certified copy of so and so, exhibit 9, certified copy of deed number so and so, dated so and so, copy of possession certificate dated so and so. However, he admittedly, this is important. However, he admittedly stated that his brother Subrato Das Chaudhary purchased 2 biga 8 chata from their mother by registered deed number so and so. He has also equal share with his brother and has no right in respect of the property left by his brother. This is very important, my lord. I am the legal heirs of my lord the Subrato Das Chaudhary, my lord, who purchased 2 biga 8 chota of land from her mother, my lord, by deed number so and so in the year 1980. He has equal share with his brother and has no right in respect of the property left by his brother, Subrato Das.
So where is the pending?
My lord, there was also a partition deed which has been exhibited as 5, exhibit number 5, that is the copy of partition deed dated 77, deed number 77 dated 14/2/1991. Similarly, exhibit 2, who are the neighbor, exhibit PW 2 to 4, who are the neighbors, supported the case of the plaintiff in respect of the possession of the suit in question, but they are dark in respect of the document execution thereof. Therefore, my lord, the partition deed has been duly exhibited, duly proved, my lord. So the facts means, my lord, the land in between the brothers, my lord, the plaintiff as well as the predecessor of the present defendant number 1 to 4, my lord, the land has been duly partitioned by way of exhibit 5. Contrary, in the evidence, DW1 revealed that the fact of the Jayanto Das and the predecessor of the defendant number 1 to 4, Subrato Das Chaudhary, were own uterine brothers. They jointly purchased land measuring 2 biga 8 chata covered by dag number so and so patta from his mother in the year 1980 with specific boundary, and after purchase both of them enjoyed the property nationally in exercise of their possession. Out of necessity and avoid future dispute, brothers have decided to their land, purchase land as well as the land including the suit land mutually partitioned and executed registered partition deed number so and so. And thereafter, each of the brother exercised possession of their respective share of land. Thereafter, the predecessor of the answering defendant number 1 to 4, Subroto Das, made a gift deed in favor of his wife Nilima Chaudhary and gave her land measuring 13 katha, 3 chota, 5 Gonda with a specific boundary and sold Dona Nilima Das Chaudhary since then exercised her possession over the suit land. Subroto Das Chaudhary, while executing the gift deed number so specifically mentioned in deed number so the said fact is reiterated in evidence of DW number 2 and 3 and stated that there was partition of Ismaili land between plaintiff and his brother Subroto Das Chaudhary. Further, it is evident from the cross-examination of PW1, this is important, my lord, that the equal share with his brother and he has no right in respect of the property left by his brother. Subroto Das, there is also a partition deed which has been exhibited as exhibit number 5. That is the copy of partition deed number 77 of 14 dated 14/2/1991. Thus, this is the finding. Thus, from the evidence of both the sides, it is made clear, amply clear, that the suit land in question has already been partitioned and fell in share of defendant number 1 to 4. Accordingly, the instant issue is decided affirmative. So, my lord, this has been, my lord, affirmed, this finding also affirmed by the learned appellate.
First appellate court.
First appellate court.
Okay, okay. We'll resume after 5 minutes.
My lord.
Yes, Mr. Sharma.
Now, in relation to my substantial question of law, which is at page 4. One, and 4. But so far, my letter brother's submission as regards to section 22 is concerned.
Over it is volume.
My lord. Basic condition is such that since there is a partition, so we cannot claim the right which is reflected in section 22 of the Succession Act. That is the basic contention. Now, what happened, my lord, so for partition part is concerned, whether the learned court below come to the conclusion that the partition was given effect to, number 1. Number 2, whether the partition did which we have cited without, my lord, suppression, whether that partition deed was accepted and proved. That has to be looked into by the trial court as well as the first appellate. While I have, my lord, submitting that partition deed, my contention was such that yes, there was a partition in between two brothers. But so far that partition part is concerned, that was not given effect.
Not given?
Effect to, my lord. Because that was, my lord, in writing we have given written something, my lord. But so far partition part is concerned, it was not practically applied. So no partition was taken place in practical. But the learned court below, particularly the trial court as well as the appellate court as a whole, the partition was taken place. There was partition. And when there is partition, I cannot claim the right under section 22. Now, another question arises. When I was put some questions as regards to my partition deed by the defense, they have objected the partition deed. Now, can you they cannot turn back. Again, yes, there was a partition. They put a question to me. Even while I have submitted the document, partition deed, which I have denied that it was given effect to. They put a particular question up. May I, if your lordship permits me, can I read that part of the matter? So for partition part is concerned. BW1 was the plaintiff, my lord. Exhibit 5 is a certified copy of the partition deed. It was put under objection by the defense. Page number 3 of evidence. Rush. That is not on record, my lord.
It is not.
It is not on record, my lord. I am
It is
pointing,
not- It is not before your lordship.
but
He is reading of his own.
because I have
It is not
prepared,
annexed to the memo.
I have prepared the question, substantial question of law. Basically, after going to the entire evidence and record as well as the judgments. Because it is with me, my lord, not before lordship. It is with, after going to that particular portion, I have seen that yes, when the partition deed is denied, how the court can hold that partition was taken place. That is why question number 4, my lord. Substantial question number 4.
But
You
unless,
cannot object.
unless,
because it is a
unless,
certificate
unless
of
those
our
are
court.
before your
No, Mr.
lordship.
Sen, let him complete.
I am not disturbing you
Hmm.
while you are arguing.
Yes.
Whether for non-consideration of violation of preemptive right.
No, the copies of this evidences are available with you.
Yes, madam.
You can furnish it to the
Yes, sir.
court master.
I have given the tick mark.
Yes.
The portion.
Okay.
I have the certificate. Cross part, page 2, madam.
Page number?
Page number 3. Exhibit 5 is a certified copy of partition deed. It was put under objection. Cross part. Third paragraph.
Page number 3, third paragraph.
Third paragraph. Exhibit 5 is a certified copy. Have you also got it?
No, no. Page number 3.
Of my cross examination. Cross part.
Yes, under objection.
My lord, so far that part is concerned, my lord. It was put under objection. That particular deed was put under objection, my lord. When the deed was particularly under objection, and when my statement was there, that the partition deed was there, but it was not given effect to. That means there was no partition at all. Now the Buddha courts below has hold that on the basis of that particular partition, we cannot claim the preferential right. That was the basic findings of the learned courts below. All the courts, appellate courts as well as the learned tribunal. My lord, so for this particular part, page 36 of the learned tribunal courts below, as regards to the preferential rights, decision and the conclusion of the learned tribunal. Page 36. As to the issue, my memo. As to the issue of the right of preemption, issue number 6, it is worth mentioning in this issue that the preemptory right is not
Paragraph number 9.
paragraph 9,
Yes.
page 36.
Hmm.
As to the issue of the right of preemption, issue number 6, it is worth mentioning in this issue that the preemptory right is not an absolute right of a person, but it is a preferential right of person who is co-sharer, relative, neighbor of adjoining land, subject to fulfillment of prerequisite condition. The prerequisite of this provision is that there must be a sale and duly registered, and soon after intention of purchasing the land shall be communicated to the vendor claiming the preemptory right. It is not necessarily be that the sale is complete and then that this right accrued, but also accrues after payment of consideration of the possession is delivered. Under section 22 of Windows Succession Act 1956, inter alia provides that an interest in any immovable property of interest that divorce upon two or more heirs of any one of such they have proposed to transfer his or her interest in the said property. The other heirs shall have preferential right to acquire the interest proposed to be transferred. In that light, the plaintiff may have preferential right over the land in question, but in the present case, the suitant is already been partitioned among the legal heirs, that is between the plaintiff and the brother of supervision by agreement 5. Now, this is the basic, my lord, point that the learned trial court pillars hold, that since the land has been partitioned between the brothers, the preemptive right they cannot claim. Accordingly, by stepping into shoes, the learned the late supervisor thus agree that even number 1 acquired absolute ownership has been thus one heir. The plaintiff learned counsel humbly submitted in this written argument it has transferred never been in possession of the suitant, but had been stated that one of the brothers. So far that exhibit 5 is concerned, partition is concerned. The learned court below trial court below hold that since there is a partition and exhibit 5 is a partition B, and since there is a partition, I cannot claim the preferential right. That is also on same footing the learned appellate court below has also hold as such, which is at page, my lord, 45.
Page number
57, my lord.
Yes. Para number?
My lord, para
16.
number 16, man.
Yes.
From exhibit 5, the registered deed of partition number so and so, it would appear that the land which was parceled by the plaintiff and the predecessor of the defendant 1 to 6 of partition between them. So it was also same. So for measurement is also accordingly hold as such as according to the trial court below. Subsequently, my lord, the partition deed clearly reflects the Daksh and Patta as well as the respective boundaries of the partition land between the parties, with further condition that neither party would advance any claim over the land in their respective share at any point of time, failing which such a claimant would be held responsible under penal law. The said deed is produced by the plaintiff in original. This court finds it difficult to understand as to how the plaintiff is making a plea that although the partition deed was prepared, it was not acted upon, unless then until the deed of partition is nullified by a decree of a competent court, it cannot be held as invalid in form. So, existence and the effect of the partition deed has also been taken up by the learned appellate court below. That is why, so far the deed is concerned, since it has not been acted upon, and since it has been denied and disputed by the defense, then the learned courts below ought not to have taken into consideration that particular deed while refuting my right, which I have claimed. That is why, my lord, question number 4 and 1 will come. Entire records will reveal and all the evidence, all the witnesses, what they have stated as here. When I have denied their possession, as per section 106 of evidence, it is the duty of the defendant that they have to show that they are in possession. I am denying their possession. They are living separately, they are living outside the suit land. But without exhausting the provisions, as well as without exhausting the procedures so far 106 of Evidence Act is concerned, they failed to prove their possession over the land, which I am also possessing along with my brother. So here, question number 4 and 2. They have also stated that the one cell deed was executed. That was never proved, my lord, at all. Never proved. Without suppression of material facts, I have placed everything before the learned trial court. Yes, there was a partition deed, but that was not acted upon. I am possessing the land. That is also I have stated. They are living separately. Yes, they had possession, but they are living separately. They are staying outside. They have never been in possession over the land. The land is a jute land, my lord. A jute land, my lord. So I have the right, but I am not claiming the right to an interest. The difference is such that I am not denying the right to an interest of my brother, but I am claiming the preferential right because he had the right to sell it. My right was such that before selling it to others, the same be sold to me first. That right was claimed by me. I am not claiming their title. Preferential right has been claimed. Before selling it to others, third person, strangers, let it be sold to me first. That right I had claimed. So they cannot curtail my right without following the due procedure of law.
So in that case, there's a substantial question of law has to be recasted.
Yes, one can be, my lord. Whether while denying the partition deed, when there is no existence of partition, whether right of preemptive right can be curtailed. 4 is, my lord, one of the point, my lord, that can be explained. And so for purposity part is concerned.
So this question number 2 and 4
My lord.
are the substantial question of law.
Right.
But the 2 has to be recasted in view of this denial of Exhibit 5. Denial of Exhibit 5. Yes,
Lord,
Mr. Sen.
May I submit? My lord, so far as my lord, my learned friends has submitted, my lord, with regard to the my lord, the existence or my lord, the of partition deed. My lord, he says that we rather objected it, but at no point of time, my lord, we have objected it, my lord. We never objected it. Rather, it was our case, my lord, in our written statement. We have categorically stated that since there is a partition deed, my lord, and it was acted upon after partition, we are, my lord, possessing the land with our respective boundaries, respective, my lord, demarcation, and my lord, accordingly, my lord, the partition deed, my lord, which has been duly registered, it was acted upon, and it was proved before the court of law, my lord, as per the Evidence Act. My lord, Exhibit 5.
No, that is not denied by him. But his submission is that it was not given effect to.
No, that is not correct, my lord. That is what his my lord, to some extent is not correct, because
that burden
both
goes to
the
me,
No, I have seen the cross-examination part of PW1.
my lord.
There you have denied the execution of this Exhibit 5.
No, my lord. Now, suppose, my lord, if I say something in oral,
having denied execution of Exhibit 5, you cannot take the benefit of the same.
my lord, I have not denied, my lord. Why? How can I deny it, since it is my specific case in my written statement? My lord, I have not I cannot deny it because
No,
unless,
no, no,
suppose
Mr.
I,
Sen,
suppose I
let the-
deny, my lord.
Mr. Sen, let the
Unless-
record come, we will hear you.
Well-
We will admit the appeal.
My lord.
Heard
Your-
Mr.
As your lordship,
Sharma,
please, my lord.
learned counsel for the appellant, and also heard Mr. B.K. Sen, learned counsel for the respondent. Then also peruse the memo of appeal and the grounds mentioned therein. And the impugned judgment and order dated 16/12/2023, judgment and decree dated, no, judgment dated 16/12/2023 and decree dated 22/12/2023. Passed by the learned additional district judge Hailakandi, Assam, in title appeal number 5 of 2024. Whereby the learned additional district judge Hailakandi has dismissed the appeal and affirmed the judgment and decree dated 14/9/2016, passed by the learned civil judge Hailakandi in titles of number 12 of 2011. This second appeal is admitted on the following substantial question of law. Number one, whether the learned first appellate court as well as by the learned trial court has committed any error in holding that preemptive right of the appellant can be curtailed and denied on execution of sale deed, within bracket exhibit 6, 7, 8, and 9, and failure to prove the gift deed relied by the respondent, where the appellant's interest over the suit land through his uninterrupted interest subsists in view of denial of execution of the partition deed exhibit 5. Number 2, whether non-consideration of the violation of preemptive right envisaged by the Hindu Succession Act 1956, the learned courts below have correctly decided the issues in the impugned judgment and decree. Let notice be issued to the respondents, returnable in 4 weeks. However, no formal notice is required to be issued since Mr. Sen, learned counsel for the respondents, appears and receive notice. You are for all the respondents?
My lord.
Recessal call for the records from the learned court below. Please the matter after 4 weeks.
Yeah, actually, my liberty may also be given to me. So at the time of hearing, I may raise another, we had one additional my lord.
Okay, okay. However, liberty will remain with the, no, that is the prerogative of the court, not mine.
My lord, yes,
Ah.
yes, that is.
So
If necessary, we will frame additional list.
This will suffice, my lord.
I
this-
also therefore, so for my lord, suspension of the impugned judgment.
And my lord.
I am my lord 59, my lord.
Oh, staying operation.
Stay up.
Okay.
That way. Another, my lord, I is there, my lord, for temporary injunction. Notice
lord.
maybe, notice will provide that is.
In the temporary injunction, let notice go. And the other state.
But number 14.
Obliged, deeply obliged.
I have some preliminary, I have some preliminary objections also. If I may show that to your lordship, and then I think they are also waiting the senior advocate who's coming. So I think.
Yes.
If your lordship may see the order of 23rd July first.
Order?
Of your lordships of 23rd July.
23rd July.
23rd, yes, I'm grateful. Lords. Your Lordship have it?
23rd July
24.
There is no such order.
23rd, 230724. It's in this matter. I have 23rd July, 23 July. It is in the civil 2175. It's in the miss case.
Miss case.
Miss case of Asawai. Miss case of Asawai.
Miss case number
2175. Oh, miss case number 217. I civil 217. I'm sorry, my lord. I was.
Yes.
I'm grateful. Heard so and so, my lords. I will read the second paragraph. This interlocutory application has been filed for expeditious disposal of the FOA number 3124 as for vacating the stay order dated 12th of June 2024 and to bring on record the order dated 15th of July 2024 passed by the Supreme Court in SLP number so and so. After hearing the learned counsels of both the sides, the prayer of the applicant is allowed. FOA so and so shall be listed on 6th of August 2024 for hearing. Mr. Hazarika shall do the hearing on 6th of August at 2 p.m. through video conferencing. Then interim order shall continue. So, my lords, your lordship had directed them because, my lords, against the interim order we gone to the Supreme. May I now take your lordships to IA 2175? Your lordships have that. In the Supreme Court order, our grounds before the Supreme Court, and when is my preliminary objection? Then I think matter will be clear. Your lordship has IA 2175.
Yes.
Then your lordships may see, my lords, page 16. Your lordship may first see the order of 12th of June 24, page 50. Page 50.
Page
50. 50.
Yes.
Sure. Heard learned senior counsel Mr. Deedas assisted by so and so, appearing for the appellants. Heard Mr. So and so, U. Hazarika, senior counsel assisted with Mr. R. Hazarika. List this matter again on 18th of July for hearing. Till then, the impugned order dated 19th of April passed by the learned civil judge, senior division number so and so, arising out of title 2 number so and so, shall remain stayed. This was in the second hearing. We approached the Supreme Court against this order. At page 16 is the order.
16.
But I'm great.
Yes.
This is the order of 15th of July. Your lordship may notice in the top left, middle left. The trial court, I'm reading the order. The trial court by an order dated 19th of April 24 granted an injunction against the publication of alleged defamatory articles. The High Court by the impugned order dated 12th of June 2024 stayed the order of the trial court and listed the proceedings on 18 July 24. The proceedings are pending before the High Court. In view of the above factual background, we are not inclined to entertain the special leave petition at this stage because it was the pendency of the appeal. However, the petition may move the High Court for expeditious disposal of the proceedings. The High Court is requested to take up the proceedings with reasonable dispatch. The special leave petition is accordingly disposed of. The ex parte disposed of, it's not dismissed. Pending applications, if any, stand disposed of. Some of my grounds are there. Your lordships may see page 57 are my grounds. The grounds are there.
Yes.
57 other ground. Or that is in contradiction of the Honorable High Court's own earlier order, the 30th of May, which has not been complied with. In the said order, while admitting the appeal, the High Court had called for a scanned copy of the lower court record as the respondents had filed an incomplete paper book, not filing 12. Actually, it is 15. We have corrected the way affidavit. 15 out of the 21 documents relied upon the plaintiff, for which reason the lower court record was called for. On the subsequent date, when the impugned order came to be passed, the said record had not been received and the record remained incomplete. Then record for that as a consequence, ground B, of the lower court record not being available, the impugned articles, subject matter of the disparagement and defamation suit filed by the petitioner, and also the subject matter of the impugned order before the Honorable High Court were not available for the Honorable Court. For that, though the order of the trial court was passed on 19th of April, service effected on 22nd of April 24. However, the respondents had not complied with the order of injunction passed by the learned trial court, directing the respondents to pull down the impugned article, and that is more than 50 days after passing of the order of the trial court, and no interim order would stay in the intervening period. The petitioner, apart from filing an application on the Order 39 Rule 2 A before the trial court, also placed before the Honorable High Court on affidavit the record of non-compliance of the order challenged by the respondent for the Honorable High Court. This honorable court in the case of Prestige Lights reported in so and so has gone to the extent of holding that an interim order, final order has to be complied with without reservation. And for disobedience of such order, the court will be entitled to refuse the party on merits. This submission in respect of willful disobedience was disregarded by the Honorable High Court in the appeal order. But the Honorable High Court has failed to appreciate the settled law as laid down by this Honorable Court in the case of Wonder versus Antox reported in so and so, that it is not permissible for an appellate court to interfere with the exercise of discretion by the court of first instance and substitute it with its own, unless where the discretion has been shown to have been exercised arbitrarily or capriciously or perversely, or where the lower court had ignored the settled principles of law regulating grant or refusal of interlocutory injunction. I'm not going to read out an extract because I will read it out in the submissions, of that judgment. I'm just showing the lordships the ground. And then ground E is at page 61. For that, the Honorable High Court has erred in passing the impugned order, the ground E, dated 12th of June, whereby means of a cryptic one-line order, the Honorable High Court has interfered with a well-considered judgment and order dated 19th of June 24, passed by the learned judge of the Kamrup District Court, granting interim injunction in favor of the present petitioner, as against the respondents from publishing, posting, and circulating disparagement of the plaintiff's services, and also to remove the defamatory articles making false and baseless allegations against the petitioner, thereby causing irreparable loss and injury to the petitioner's reputation and business. Then, the ground F is that incomplete record being filed, the content not be fabricated. I will not trouble your lordship. Then we also may come to ground G, For that, the impugned order has the effect of causing irreparable loss, long-standing reputation in business, which has been seriously prejudiced by the impugned articles, and therefore the learned trial court was passing the order so and so. Ground H, I will read, has failed to consider the law laid down by this honorable court in the case of Prestige Lights versus SBI, reported in 2007-8 SEC, wherein it has been held that if a party is in contempt, it ought to purge the contempt before being given an opportunity to be heard. It has been held, and I will read this because this is relevant. They have been in contempt of that order, they have not complied. An order passed by a competent court, interim or final, has to be obeyed without any reservation. If such order is disobeyed or not complied with, the court may refuse that party, violating that such order to hear him on merits. We are not unmindful of the situation that refusal to hear a party to the proceeding on merits is a drastic step, and such a serious penalty should not be imposed on him except in the grave and extraordinary situation. But sometimes such an action is needed in the larger interests of justice, when a party obtaining interim relief intentionally and deliberately flouts such an order by not abiding by the terms and conditions on which a relief is granted by the court in his favor. Rest of the grounds, some of them are repetition. I will not trouble your lordship with that, more or less. But these are the substantial grounds which I have done, and I have I may just point out one conceptual issue to your lordship. They have in their appeal, they have said it's a case of defamation. It is not a case of defamation alone. Defamation is when someone's reputation is affected. My suit for injunction is for disparagement, which is actually disparagement and defamation. Disparagement is when someone's goods are being spoken about, or there's slander, libel, defamation in respect of goods, and there's economic loss which is caused. I today, I am FICGI. I, today run one of the largest coaching institutes in the country. The fact is, coaching institute for IIT joint entrance examination. So there I have 78 institutes all over the country. I was planning to start one in Guwahati as well. Now, and I had received the query. Then, what happened between and pursuant to that query, on 25th of March, I will check the lordship. I'm just explaining the facts here. On 25th of January, one institute from Guwahati got in touch with me, saying that we want to start, we are franchisee of that. Then, those impugned articles came out, 4 impugned articles published in the space of 4 days. One article on 12th of March, 2 on the 14th of March, and 1 on the 18th of March. All saying that I'm financially incapacitated, I have various liabilities, etc. I am going to collapse, and therefore, that led to undermining of confidence, because students will not come to me if they feel that an institute for which they are paying 1.5 to 2 lakhs of fees is not being able to will not last that long. So, I approached your lordships, and then this institute from Guwahati, then got in touch with me. And then they said that we want a clarification on that, because if I'm taking a franchisee from you and investing money, why should these articles not be, please explain those articles. So on that basis, my lords, I approached the learned trial court on a suit for disparagement because it's an economic loss. I will explain that to your lordship. And a learned trial court granted an injunction. They were served on 19th of April 24. Then, well, on 22nd of April, they were served by email of all the copies, including the plaint and injunction order. 26th of April by speed post. The matter is posted before the trial court, I think on sometime on 10th of May. They appear there. Then they file, but they do not file any reply. They do not file any response there. 13th of May, they file. This appeal is listed before your lordship. 15 out of 21 documents not filed. Because I'm on caveat, I'm able to point out 50. There is material concealment. Documents relied upon in the plaint, documents which are the subject matter of defamation are not filed by them. Material concealment. So I take that objection, the line of trial, your lordship's call for the trial court record. But then on the next day, trial court record is not available. And whether this order comes to be passed on, for which we have to go to the Supreme Court because after clients are instructions, because this affects their business. Then they are in breach also. We filed a 39(2) capital A before the trial court. We filed that application here also pointing out how that they have not complied with our order. So on 2 counts, on material concealment of material documents and on the violation of injunction order, they have sought an equitable relief from your lordships of stay in the first appeal because it's against an interim order, which they are not entitled to. So if I may just take your now lordships through those points because that is important for me, then I think my learned friend, because after lunch he may be available. So then I think they can take over from there. If your lordships don't mind, I will also give a written note to your lordships and the matter conclude. If I may take your lordships first to may I take your lordships to page 81 of the injunction order. Main appeal. I'm sorry.
Yes.
May I read it? It's a short order, I'll read it all. It's a very detailed, well considered order. The instance in this case has been registered on petition number so-and-so, dated 19th of April, under order 39 rule 1 and 2, read with section 181 CPC. Filed by the plaintiff petitioner granting ad interim injunction restraining the opposite parties, their agents, representatives, assigns, or any other person related to them till the pendency of the present proceeding from posting, publishing, or circulating any posts that amount to disparagement of plaintiff services. This is very important because it's an economic concept. As well as immediately take down the impugned articles or any other similar article or any other post, write up or material concerning or in relation to these impugned articles against the petitioner. In this regard, the petitioner plaintiff has vide title suit number so-and-so with a prayer for permanent and mandatory injunction and damages on account of defamation and disparagement against the opposite party's defendants. The contention of the learned counsel for petitioner plaintiff is that the petitioner herein is a registered company for the purposes of imparting quality education in order to help students secure admissions in various premier institutes such as Indian Institute of Technology across India, especially for training students for competitive exams. It has 78 centers in India and it also has its centers in Doha and Bahrain, which has nearly 60,000 students with approximately 3,000 employees. Petitioner plaintiff provides online classes, test papers, etc. for the students of Assam and Northeast at present. On the other hand, the defendants run business to provide news in text and to videos. Analysis, data and tools on investing across diverse asset classes, personal finance, the business sector and economy, as well as operate multiple social media pages, being Facebook, LinkedIn, X, that is erstwhile Twitter. The learned counsel for the petitioner alleged that opposite parties defendants through the series of 4 articles dated 12th of March 24, 14th of March 24, and 18th of March 2024 are trying to alter and impact the perception of the general public and the consumers of the petitioner plaintiff by disparaging the petitioner's business, stating that the petitioner has deliberately suspended salaries of its employees and that there are potential cash flow concerns amidst stagnating growth and rising competition. Further, the impugned articles created an apprehension that the petitioner might be facing a liquidity crisis in the future and thus harassing its employees and belittling the students, which is clearly far away from the truth. It is submitted that in the impugned articles, the petitioner's position has been completely misconstrued and misinterpreted. In fact, the effect of the impugned articles is that the petitioner is not doing well and may collapse in future, which is false. However, this effect will lead to prospective customers to see the plaintiff and naturally its services to be less credible. Pertinently, no employee or any partner has made any grievance about payments, and there was in fact internal restructuring about salaries and incentives, which is now resolved. So there is no grievance by anyone. Therefore, there is absolutely no basis for such article. The impugned articles have led Digitap, a coaching institute, to put the plan of opening a franchisee center of petitioner on hold till further clarification of the petitioner. In this regard, a letter on behalf of Digitap was addressed to CEO of the petitioner on 25th of March 2024, wherein they had specifically cited articles published by Money Control being the reason for their partner's apprehension. Furthermore, the petitioner contended that in view of the above publication by the opposite parties, the petitioner's reputation has suffered both in the eye of general public and amongst his employees, and hence prayed for ad interim injunction against the opposite party. I have heard learned counsel for the petitioner on the aspect of ex parte ad interim injunction against the opposite party, dispensing with the need of service of notice. Upon hearing and perusal of the petition, as well as the relevant documents filed by the petitioner, it transpires that there was a series of publications in moneycontrol.com portal and in other social media, including Facebook, LinkedIn, X, erstwhile Twitter, about the petitioner's institute company regarding withholding of employee salary and touching upon the petitioner's bankruptcy as alleged by the petitioner. It is also appears that a tuition cum coaching institute, namely Digitap, who are intending to open a Fiji franchisee in Guwahati for upcoming academic session, sought clarification on 25th of March 24 from the petitioner company about the said development, thereby causing harm to the reputation of the petitioner. It appears that there is a prima facie case to be heard. Besides, if the opposite party continue to publishing moneycontrol.com and portal and other social media like Facebook, LinkedIn, X, erstwhile Twitter, about the petitioner's institute company, the petitioner or intends to continue or repeat the alleged publication, there is prospect of such immediate further pressing injury to the petitioner, that the balance of convenience lies in favor of the petitioner. Further, in the event of petitioner plaintiff is not protected in the interim as prayed for, the petitioner plaintiff will suffer from irreparable loss and injury. On consideration of the facts and circumstances and the above triple test, I am of the considered opinion that the relief claimed by the petitioner is urgent in nature and the purpose of injunction is likely to be defeated by delay. As such, in the interim, the opposite party agents, defendants, their agents, representatives, assigns, or any other person related to them are restrained from posting, publishing, or circulating any posts that amount to disparagement of petitioner plaintiff services, as well as immediately take down the impugned articles dated 12th of March 24, 14th of March 2024. There are two articles of 2014 March and 18th of March 2024, or any other similar article or any other post, write-up or material concerning or in relation to these impugned articles and against the petitioner till date fixed. So shall take steps for service of notice upon the petitioner parties as per order 3923 CPC. Why not made up, please do. And it is fixed on the 10th of May 24. Where they appear, and then they file the appeal on 13th of May. And now, and they have not in fact filed any application for modification or vacation of stay under order 39 rule 4, which they could have. They come straight away before your lordships, and that too by concealing material document. Fortunately, because we were on caveat, we were able to point out on that thing. But that itself, my respectful submission, this entitles them. Mamala, I mean, just before I take your lordships to that, may I just explain one small fact to your lordship? What happens is these are portals. When we go to the internet, when we click, we see these articles. Now, their portal is a very big portal, moneycontrol.com, because you get news about the stock market and everything. They have 5 lakh permanent subscribers. So if any news comes, and if I'm a subscriber, it will come immediately on my mobile phone. It will come on his mobile phone, your lordship's mobile phone, if your lordship has that subscription. 1. 2, Milods, it is also, their posts are also given on Facebook. Cross-posting, that is called. Facebook, LinkedIn, which is Milods recruitment, very important recruitment portal. And then Milods on Facebook, Twitter. So Milods, it has a cascading effect, and it is there at every point of time. It is not that it is like some newspaper that I read today in the Assam Tribune or Protidin, and then the news stays there, and then it goes away. Here, the news is permanent. People start commenting on, people can share that. So the effect is very wide. Which is why the learned judge saw the cross-posting on media, because this is very important. Which is why the restraint had come. I think I'll continue with this one. So, the violation now, if your lordship will see, if I may come to page 223, 224 of the appeal. At page 229, I filed this affidavit to setting out a tabular chart on how. What documents? Page 229.
In the main petition?
Main petition, I'm grateful. 229.
229
It's a-
is not
It's an
there.
additional affidavit. I can hand over a copy. Yes. 229. It is an additional affidavit in the appeal. Your Lordship has it?
Yes.
Miller. So, Miller, I have the list of documents. This is the tabular form and list of documents filed along with plain and missing in the appeal. Copy of board resolution missing. Copy of email dated 12th of March 24. Yes, it is filed. 2 and 3 are there. 4 copy of letter dated 22nd January issued by Digitup to the plaintiff. No. This is the when the proposal for franchisee comes to me. Printout of the 5 and 6 are there, Miller. These are printout of the impugned article. Your Lordship will come to 7, page 230.
Yes.
7, it is not, an impugned article is not filed. Then Miller, printout of the article now, my reputation, which I spelled out at page item number 9, that is not filed. Because that sets out my reputation as to how big I am. India Today had given a write-up on me. I will show that to your Lordship. Then Millard's page item 11, your Lordship will come to page 231. Not filed. Copy of email dated 27 February, 3rd of March and 8th of March sent by Mr. D.K. Goel. That is my chairman had written to them, where I offer an explanation. In fact, they send a email to me at 7:30 in the morning that we want your response at 10:30. My office opens at only at 10:30. And by the time I give them the response at 3 o'clock, they have already published it. That is the manner in which they have gone about in this. I have put that averment in the plain mail. I will show it to you. The printout of post an article on the plaint on LinkedIn, where Millers it is posted on that same article is accessible on other sites, LinkedIn. That is not annexed. Printout of the summary of article in LinkedIn, again not there. Again on LinkedIn, it is not there for 13, 12, 13, 14, 15. Then 12, 13, 14, 15 is Instagram, another account. That's another very big social media website. It is not, they have not disclosed that. The print at 16 is when a post on X, Twitter, which is done by Mr. Elon Musk. That is not there. Then page 17 Millard print out the post an article on Twitter. It is not there. 17, 18, 19. And Millard's 19, 20, 21 Millard's these are 19 is print out on it is the publication on Facebook. It is not shown. 20 is showing the number of subscribers because I showed that they have 5 lakh subscribers. That is not shown because it shows the gravity, and 60, 21 is there. Well, I'll continue after that.
Resume at 2.
Great.
You can choose a date from him.
Lordship?
You can take a date from him.
Yes. Always, Lordship.
Yes, Mr. Hazarika.
Lord, may I just take a liberty of making a mention? Item 18 on the today's list, madam.
Yes.
Well, I'm led by Mr. D. Mazumdar, Senior Counsel, madam. He is on legs in court number 7, madam. It will take time. If your Lordship fixes it in the month of November, madam. Therefore, the other side.
Other side, madam, led by Mr. Ratnako Banerjee. Both outstation.
They have come from Kolkata, madam, for this.
Item number 18.
Item 18. Supplementary.
Yeah, for this number 3.
Okay. On the pair being made by Mr.
D.
Kosik, learning
I'm
counsel
led
for
by
the
Mr. R. Banerjee. Senior advocate. I'm led by Mr. R. Banerjee, Senior advocate.
Okay. With consent from the other side, press for listing the matter on
7th of November.
7th of November.
Grateful, madam.
Item number 14 to continue.
May I, now, so judgments on material concealment to your Lordship. No, General Manager Haryana Roadways. These are judgments on material concealment. And how they invite dismissal also. The first judgment, my lords, is General Manager Haryana Roadways. Your lordship has that. Lordship. Yeah. Paragraph 7, my lords. There was it is self-explanatory. The special leave petition was filed before this court. Your lordship has that. Paragraph 7.
Yes.
On 13th of September 2004 with an application for condonation of delay of 153 days delay. In the list of dates filed with the SLP, the fact that the first respondent had been reinstated in service or that his services had been regularized had not been disclosed. To crown all, a prayer for interim relief was made to the following effect. It is therefore respectfully prayed that your lordships may please grant an added interim ex parte stay of the operation of the final order and judgment dated so and so, the High Court of Punjab, Haryana. Now, it was found that since this was a false averment, then the lordships from paragraphs 12 to 16 says how concealment of a material fact, and in this case, my lords, paragraph 12. We fail to understand how even in the case of this nature, where the state pretended to be so serious in obtaining a principle of law determined by the court, such a delay took place in both filing the writ petition and also specially petition. Suppression of material fact is viewed seriously by the superior courts exercising their discretionary jurisdiction. In SJS Business Services Private Limited versus State of Bihar, this court on suppression of fact held. As a general rule, suppression of a material fact by a litigant disqualifies such litigant from obtaining any relief. This rule has been evolved out of the need of the courts to deter a litigant from abusing the process of court by deceiving him. But the suppressed fact must be a material one in the sense it had not been suppressed, it would have had an effect on the merits of the case. The said observation was quoted and approved by one of us in Arunima Borua versus Union of India, wherein the question which was raised was how far and to what extent suppression of fact by way of non-disclosure would affect a person's right of access to justice. The court notices that so as to enable it to refuse it to exercise discretionary jurisdiction, the suppression must be a material fact. What would be a material fact suppression whereof would disentitle the appellant to obtain a discretionary relief would depend on the facts and circumstances of each case. Recently, in Prestige Lights versus SBI, this court held the High Court, in exercising discretionary and extraordinary jurisdiction under Article 26 of the Constitution over and above a court of law is also a court of equity. It is therefore of utmost necessity that when a party approaches a High Court, he must face all the facts before the court without any reservation. If there is suppression of material facts on the part of the applicant or twisted facts have been placed before the court, the writ court may refuse to entertain the petition and dismiss it without entering into the merits of the case. Had the aforementioned facts been brought to the notice of this court, the special leave petition might have been dismissed summarily. Even delay in filing the same might not have been condoned. The court was not required to waste so much time when the state itself had for all intent and purpose accepted the award. So this is delay and it's allowed. So this is one. The other one, my lords, is K. Jayaram versus Bangalore Development Authority, paragraphs 11 to 13. Paragraph 11, page 819 at the bottom. This court in Prestige Lights versus SBI has held that the prerogative remedy is not available as a matter of course. In exercising extraordinary power, writ court would indeed bear in mind the conduct of the party which is invoking such jurisdiction. If the applicant does not disclose full facts or suppresses relevant materials or is otherwise guilty of misleading the court may dismiss the action without agitating the matter. It was held thus. It is thus clear that although the appellant company had approached the High Court under Article 26, it had not candidly stated all the facts to the court. The High Court is exercising discretionary and extraordinary jurisdiction under Article 26 of the Constitution. Overall, it is also a court of equity. It is therefore of utmost necessity that when the party approaches the High Court, it must place all the facts before the court without any reservation. If there is a suppression of material facts on the part of the applicant or twisted facts have been placed before the court, the writ court may refuse to entertain the petition and dismiss it without entering into the merits of the case. In paragraph 12 and 12 again in Udyami so and so, this court has reiterated that the writ remedy is an equitable one and a person approaching a superior court must come with a pair of clean hands. Such person should not suppress any material fact but should also not take recourse to legal proceedings over and above, which amounts to abuse of the process of court. In KD Sharma versus SAIL, it was held that the jurisdiction of the Supreme Court under Article 232 and the High Court of the Constitution 226 is extraordinary, equitable, and discretionary. Prerogatives which mentioned therein are issued for doing substantial justice. It is therefore at utmost necessity that a petitioner approaching the court must come with clean hands, put forward all the facts before the court without suppressing, with clean hands put forward without concealing or suppressing anything and seek an appropriate relief. If there is no candid disclosure of relevant and material facts of the petitioner is guilty of misleading the court, his petition may be dismissed at the threshold without considering the merits of the claim. The underlying object has been succinctly stated in Scruton Lord Justice in the leading case of so-and-so. I read that extract. It has been for many years the rule of the court, and one which it is of greatest importance to maintain, that when an applicant comes to the court to obtain relief on an ex parte statement, he should make a full and fair disclosure of all the material facts. It says facts, not law. He must not misstate the law if he can help it. The court is supposed to know the law, but it knows nothing about the facts. And the applicant must state fully and fairly the facts, and the penalty by which the court enforces their obligation is that if it finds out that the facts have not been fully and fairly stated to it, the court will set aside any action it has taken on the faith of the imperfect statement. A prerogative remedy is not a matter of course. While exercising extraordinary power, a writ court would certainly bear in mind the conduct of the party who invokes the jurisdiction of court. If the applicant makes a false statement or suppresses a material fact or attempts to mislead the court may dismiss the action on that ground alone and may refuse to enter into merits of the case by stating, "We will not listen to your application because of what you have done." The rule has been evolved in the larger public interest to deter unscrupulous litigants from abusing the process of court. On Kensington versus so-and-so, Viscount Weller's reading Chief Justice observed, where an ex parte application has been made to the court for a rule nicer or other process, the court comes to the conclusion that the affidavit in support of the application was not candid and did not fairly state the facts, but stated them in such a way as to mislead the court as to the true facts. The court ought, for its own protection and to prevent an abuse of his profess, to refuse to proceed any further with the examination of the merits. This is a power inherent in the court, but one which should be only used in cases which bring conviction to the mind of the court that it has been deceived. Before coming to this conclusion, a careful examination will be made of the facts as they are and they have been stated in the applicant's affidavit, and everything will be heard and urged to influence the view of the court when it reads the affidavit and knows the true faults. Whether the result of this application and hearings to leave no doubt that the court has been deceived and it will refuse to hear anything from the applicant in a proceeding which has only been set in motion by means of a misleading affidavit. The above principles have been accepted in the legal system also, which means everywhere. As per settled law, the party who invokes the extraordinary jurisdiction of the court under Article 32 or High Court under Article 226 is supposed to be truthful, frank, and open. He must disclose all material facts without any reservation, even if they are against time. He cannot be allowed to play hide and seek or to pick and choose the facts he likes to disclose and to suppress, keep back, or not to disclose. The very basis of the writ jurisdiction rests in disclosure of complete and true facts. If material facts are suppressed or distorted, the very function of the writ courts and exercise will become impossible. The petitioner must disclose all facts having a bearing on the relief without any qualification, because the principle is, as it says, this is because the court knows the law but not the facts. So if I mean, there is another judgment, they have not found the copy, I will hand it over to your lordship. It is by Justice Hima Kohli, who is now just retiring from the Supreme Court, sitting in the Delhi High Court. When one judgment was, when a document, I don't have a copy in file, but I have marked the paragraphs there, paragraphs 3, 7, and 10. The lordships may take my copy. So they had not disclosed a particular copy when the matter was taken up for admission. So by relying on 3, 7 to 10, your lordship just make it. I have marked those paragraphs. Now, my lord. Now, if I may request your lordship to just make a note of what documents is now not filed. I will just state that it is in the plaint itself. The document, it is at page 9 of the plaint, the copy letter of 22nd of January 2024 is page 9 of the plaint, which is there. Plaint documents. I think the plaint is filed separately, lower court record. Your lordship may just make a note because I'm just making my submission. Because what are the documents they have? I had showed it to your lordships earlier in the chart.
Yes.
Page 223 of the lordship will recall I had showed to your lordships earlier.
Yes, yes.
223 may also your lordship may have now. There, my lords, there's a copy of. Now, I just want to show you the lordship the relevance. Your lordship may come to item 4. Item 4, page 229. 229. It is, this is not completely copied. That's very clear. Serially number. Paging or asset 224.
Which document you were referring to?
Which I showed initially to your lordship, where the list of documents.
Oh, yes.
Yes, your lordship.
229. page
229,
number.
I am referring.
Yes.
Your lordship may think now item 4. Copy
Yes.
copy of letter dated
Yes,
20.
yes. Whole letters.
Yeah. Item 4 is not there. So what is item 4? Because I will now demonstrate your lordship how it is a material document. Because your lordships will note I read your lordship's injunction order to your lordships. In the injunction order, the learned judges observes that Digitup from Guwahati or sponsor franchisee, they had written to me. So this is the letter which is not there, which they have not filed. So it's a material document because it's a proposal which had come from me. Then we'll have print out of the impugned article, item 5. An impugned article is not filed. An impugned article which is in Hindi and which is actually the worst because it says there is no respite now. Fiji ka koi khair nahi. That is at item 5, that is not filed. Item 7. 7, I'm sorry.
No, item 5 is yes.
No, I'm sorry. 5, 6 are filed, 7 is not filed. 7 is very important because it is in Hindi. It has huge circulation. An impugned article is not filed. It is a material document. I have mentioned it. Then item 9, which is a write-up on me saying how good an institute I am. I am rated the highest, madam. If your lordship has the plain documents, I'm not document. I think the lower court record is left. Scan can be asked. Scan to be complete. Documents file only with the plate. Nice.
But this LCR was not enclosed with this petition today.
I will hand over my copy of the episode call for you. I will just show to you a lot.
Yes.
Your lordship will come to page 26 first.
Yes.
It is in Hindi. Your lordship may not be familiar. I will read out. The first one says, फिजी में सैलरी मांगना गलत है. फाउंडर ने ऐसा दिया जवाब, कर्मचारियों को दिल दहल दिया. फिजी में सैलरी मांगने वाले को खैर नहीं. There is no respite. So that's saying that I am broken down. I am not paying salaries. So this is the impugned article. I have challenged this. And there's an injunction operating in respect of that. So this is the first one which I was showing to your lordship. This is a material document, which is an impugned article. Then your lordship come to 25th of this is item 7. Then I copy of premium is that your lordship may come to. I'll take a lordship copy of premium. Premiums are as follows. 52. 52.
Is the bird?
52. 52. Now, after they write those articles, the distinction I wanted to draw. This is very important because they will go on the ground and they will cite judgment that defamation has to be protected as a higher right. But today I spend 100 crores annually and I have filed those things. I will show that in documents. In the documents file your lordship has, I spend about 100 crores annually on advertisement. This is how product, because last page, 110 out of documents file. Is a document filed with the Assam. Your Lordship, it's a chart. Advertising and marketing expenses details of Fiji Limited for the last 5 years. 31st of March 2019, Lordship, the advertisement 37 lakhs, awards and rewards 12 lakhs, scholarship 4 lakhs, total business, oh no, I'm sorry, this is all 30 crores, 63 crores total. March 2020, 61 crores, 2021, 47 crores. March 2022, total to bottom mill 70 crores. 31st March 2023, 102 crores. So in the last 5 years, I have spent 3.5 crores in building up my brand. And they will rise for false art because today, no employee has complained that they have not got salary. We are doing some restructuring and it is sorted out. But they are the ones who are writing these articles and ruining my reputation. And this is the peak admission season. So now, whatever they may say, I'll put, but I have more or less substantially concluded my case. Because my submission is a preliminary ground, it has to be dismissed on this.
Yes.
Senior counsel on lakes on court number 1, my lord. So we'll complete our part on any date on 6th, if it's possible.
Pardon?
On 6th of September.
6th of September.
6th of September. Because he's not free, my lord, on lakes in court number 1.
6th of September is next Friday.
Friday. But we'll require only half an hour, not more than that.
Half an hour.
Yes, it can be.
Well, today the matter is fresh, we could have, or Tuesday, no?
Because he has completed, so our will.
Is he present in the court number 1?
He is there.
Are you sure?
Yes, he is here in the court.
Well, they have already been difficult. They have taken this matter.
No, Mr. Surma.
Yes, yes.
And the interim is
My
continuing.
court master has already sacked the court number 1.
He is in court.
Your senior is not there.
My lord.
Are you submitting correctly?
Yes, no, my lord, half an hour ago he was there, my lord. So that was the instruction, my lord.
So then 6th of September?
Well, I have no issues, but my only thing is that since there's a continuity, Tuesday,
Tuesday.
I will do it on I will do it on video conferencing from Delhi. I don't have a problem.
Okay.
Because the parted matter, I mean, it cannot it should go from day to day.
That's why I'm not delaying, my lord. On 29 today, if possible on 6th of Friday, half an hour it will require.
Tuesday, why not Tuesday?
Tuesday he again blocked, my lord. That's why.
Blocked for what? He's not in the High Court.
Is it not your work?
He'll be out of station, I think in the Arunachal Pradesh. If it's
Well, because they have an interim order, this is
only 4 days, I'm praying for accommodation.
today you should have done, no?
Friday is a motion day.
My lord.
So we will not be able to
do it before that.
Hear you.
No, your lordship may fix a date, they can do it because after all, senior advocates are engaged from a day to day. I mean, if I'm not there, someone else, Mr. Roy is there. One date I was not there, then he can engage someone else. I'm not saying that he should, we have always accommodated them. I'm not saying that. But the point is, it cannot be, because they are enjoying an interim order that they will continue like this. It's not being fair to us. Because the dates had been chosen by them. I mean, I come from Delhi, they are not available. I have made myself available.
The problem is, my lord, today we have the difficulty anyway, because it is they are from this. Yes, last occasion they have faced for fixing the matter today.
He was there also in court.
We have.
Because Das was present when I was there. He said, in fact, I said Tuesday, he said no. I said Wednesday, he said no. Thursday, he said yes. I remember. He had agreed to Thursday, my lord. He was the one who was suggesting. I'm not the in-station lawyer, he's the in-station lawyer. And he was in court today. Anyway, I mean, I have nothing to say.
Only 4 days I'm praying, my lord. Let it be on 6th or after
6th is the motion, then have it on Thursday.
Or after 6, my lord.
No, Thursday,
Thursday.
next Thursday.
Your lordship may keep it as part heard.
Yes.
I'm grateful.
Heard, Mr. S. Sarma, learned counsel for the appellant, and Mr. U. Hazarika, learned senior counsel, assisted by Mr.
Rinku Hazarika.
Learned counsel for the respondent. Heard in part, lays the matter as part heard on Thursday.
On 13 Milord. 13.
Sorry.
Coming item 2.
Mr. Roy is also there, my lord. 51.
Okay. Okay.
Mr. Roy also appeared. Both of us appeared. Great. Oh. I'm grateful.
Your Lordship, I checked the record, Your Lordship.
Yes.
There are 6 compilation, Your Lordship. 5 compilation are sheets. The 6th one is loose papers. And the loose paper, the orders are there when our witness have been examined, Your Lordship. I have marked this flag.
Achha.
These are the dates. And the records are missing, Your Lordship. May I hold an inquiry about how the record got missing? Cross-examination. Those orders, they have been examined. How this file is loose. All are tagged. So Lordship will see. 5 are all sheets. Well, this is the only one which is loose.
On that day, when we have pointed out, we have placed the court has searched the record, and thereafter court has asked to verify. Then we verify we have not found.
I'm not blaming. It is from the record. The lower court, they have. How can this be loose, Your Lordship? All are stacked. And they have been cross-examined, Your Lordship. The orders are there. And the cross-examination is missing. In fact, the dates which are the copy which I have given, the dates are telling also, Your Lordship. In my this thing. Or Your Lordship may fix it at Tuesday. I may be having photocopy. I'll supply that photocopy to Your Lordship.
Tuesday.
Yes, sir. Tuesday.
There is a procedure for is how to make the record. There is a procedure. They have
Procedure it is missing here.
They can. I have nothing to do, Lordship. How they will place, I have no objection to that.
It is already there in the record.
No. If certified copies of the depositions are available with both the parties.
Yes,
then-
it's there. I've given it. It's in the record. I have petition. I have put everything there, Your Lordship. Certified. I have given it. I'll produce that also. You have to photocopy of the certificate. I'll produce that document also. You give me that, because today the original record I have now. We have not brought. We could have done it. Because it has been transferred from those copies only, Your Lordship.
Okay.
Translation is there, Your Lordship. Or you can, Your Lordship, have it on Saturday. I have no problem at all.
Saturday.
Tuesday. If Your Lordship is from Tuesday, we'll have it on Tuesday, Your Lordship.
Okay. As agreed by learned advocates of both sides, arrests and list the matter on Tuesday.
Yes, sir. I may be permitted. Yeah, I'll produce. I'll file it at. I'll give you the documents of the court. Your Lordship.
Okay. Mr. Soudhuri, learned senior counsel for the appellant. Submits that he will produce the
Lordship may record that there is no
certified copies of the.
Before that, Lordship may record there is no record regarding.
No, Your Lordship, that cannot be recorded because the order says it is there. Order the cross again, the records are missing. That's why I say hold an inquiry. I am saying, Your Lordship, direct an inquiry to be how this record got missing.
I am not saying that, Lordship. I am saying that during verification in the LCR, the cross-examination part is not available. That is why he is directed to.
So that need not be said, Your Lordship. That need not be said.
Otherwise, okay.
It is on the record.
Lordship will pass this order. Lordship may record that. That is not available in the record.
That has been missing, Your not available. It's missing from the record.
Missing anything. Lordship have to record.
The record has been missing. Let an inquiry be held also on that.
No, first we have to ascertain whether it is available in the trial court or.
Yes, Your Lordship. Because Your Lordship, I may probably.
Only thereafter we can direct.
It may happen. There are some missed cases. It may be that they may tag the missed cases also.
Yes.
The 3 missed cases are also there, Your Lordship.
Yes.
They may find out from there also, Your Lordship. Missed case number 73 of 2013. Then missed case 473 of 2013. And missed case number 73 of 2016, Your Lordship. They may find it from there also, Your Lordship. It may be tagged down there also.
That is my submission.
During hearing, it has been pointed out that the original copies of the statement of the witnesses of the
No,
defendant.
cross-examination. Statements are there.
Cross-examination.
Statements are there.
Cross-examination of the witnesses of the defendants are found to be not available in the record.
Cross of the appellants, there is available. Our
Appellant.
appellants.
Appellants are found to be not available on the record. Mr. Sodhuri, learned senior counsel submits that certified copies of the said cross-examinations are available with him, and he will furnish the same before this goes on next day. In the meantime, registrar shall confirm from the learned trial court whether the cross-examination of the witnesses of the defendants are available there or not.
Yes.
On next day.
Which case number I'm doing?
In this case number, okay, Miss case number
Which case number 73 of 2013?
70,
73
73.
of 2000. There's one miss case number 476 of 2013.
476.
476 of 2013 and miss case number 73 of 2016. Your Worship. Maybe
Okay.
tacked up there also. I'm not blaming.
Okay, okay, okay.
We may find out.
Hey, kindly note it
Yes,
in
I'll
a paper and give it.
I'll just give it. I'll give it a copy.
Okay.
I'll give it a copy.
Then on Mr. Sorure, on Tuesday, it may not be possible, but because it has to come from the.
No,
trial
yes, sir.
court.
Let us, because if I can get a because photocopy of certificate, if I can give it, that we can continue with the matter, Your Worship. Inquiry, let the, why you shy of inquiry? Why you still someone? No, don't say that. Let the.
Okay.
One side you are calling for
No,
calling
no,
for
no.
the records. and
No, 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 no.
I'm not calling for the record. It's missing.
Coming item number 9.
Senior counsel is another
Who is your senior counsel?
J. Ahmed, court number 27.
27.
Last number.
What to
Shall I
do?
start, Lordship? If your Lordship permits, I can start.
No, you can start, there is no problem.
But there is
But,
a right-
whether he will.
Right to begin on that side.
No, he is available.
Actually, my understanding is going on in court number 27. Another test may be given well next week.
Pardon?
Next week, any day can do it.
Next week.
Otherwise, in this case, my lord, the defendant, they did not appear in the show it also. And even they did not appear in the appellate court also. Now they appear. Another death can be given.
Lordship may record.
They
my
file-
objection.
they
On
file-
Last occasion also, they took time.
My lord, current, because my lord, lordship can see.
Preparation of a regular second.
No,
is
in
very
the
tough,
suit,
Lordship.
in the suit, my lord, they file counterclaim, not appear, counterclaim dismissed. So it, they even after filing determination, they are not produce any evidence. Our witness has also not been cross-examined. We file appeal against the dismissal of the suit. In appeal also, they have not appeared. Now we made them party as a formal party here.
Now, formal party, Lordship,
Yes.
we are
As
the
a
main
formal party now
defendants.
they are. They have no. Lucas
On
stated
the
also.
weakness
Okay.
of plaintiff's suit.
They
Lordship
cannot,
may not fail.
cannot even contain, there is any question about the witness, my lord.
Heard Mr. Zayam,
cannot
learned counsel.
put
for
any
the
question.
appellant, and Ms. Arsoduri, learned counsel. for the investigation.
Next week, any date, Lordship?
On the affair being made
After
by
2 weeks,
Mr. Zayame, learned counsel for the appellant. No, the case is then adjourned to be listed on
27 September.
27
After 2 weeks.
September. 27
My lord.
Lordship, it's
September.
Given a long date, but can it be on?
It may be.
Not
it
possible,
may be list
before
on usual
vacation,
course, my lord.
not possible.
Lordship.
But it actually it should be come in usual course, my lord. Usual
No,
course
Lordship,
after
I
2 or
may,
3 years. my lord.
we made a mention for
Yes, why,
listing of this
my
on
lord?
last occasion.
What is the purpose? They are not appear in put the court, my lord.
Lordship.
Now we are there.
That is not a ground, Lordship.
There
We
is a
are
ground.
appearing in this.
There
case,
is a ground. They
Lordship. How
cannot.
they can say
They
that, Lordship?
late in the question. They put in the question
No,
about
no, no, Mr.
our
Ahmed.
witnesses, my lord. File on list,
Second.
At least they should inform us that do not prepare the case. I am not going to
not
do this.
necessary,
to
madam.
call motion. I have
I
prepared
prepare
the
the
case.
court. I am in the court. Not before it.
17.
17 September.
17 September.
Lordship, no more adjournments, Lordship.
Not,
Kindly
it is not a
record this.
condition.
No,
It
on
is-
last occasion
Court
also. they
cannot
could-
run on the basis of her statement, madam.
My
She
objection
doesn't
may be
will arise.
recorded.
madam.
My
She
objection
may-
may be recorded.
Yes,
Lordship.
record her exertion. My exertion also recorded. Malik, she has Lucas Lindi to argue in this case, madam.
Then why made
No,
me
no,
party?
no.
Then why made me
Because
party?
because of formal party, that is why. That's the
Then
formal party.
strike
On that day, we'll try to dispose of
ma'am.
the matter.
Lordship,
Yeah.
then they can pray for striking out our name, Lordship. In absence of defendant, they can argue their case, Lordship.
No, no.
Obliged, Lordship.
Huh?
17.
Nalagi.
17. Coming item 11.
But I have checked up the record, Miller. One page is missing, Miller, in my file, Miller. But in the lower court record, it is there, Miller.
It is on record.
Record is
Record is
receipt
available, Miller.
available.
My prayer is simple, Miller. Second appeal is very simple, Miller. The suit was decided ex parte, Miller. Thereafter, I have filed an application for vacating the ex parte decree. That was not considered and not registered. Thereafter, I have filed an CRP for seeking a direction to move this that order 9 rule 13 application before the learned trial court, Miller. That was rejected. CRP was rejected, Miller.
CRP is not maintainable, perhaps.
CRP, my lord, on merit disposal, my lord, it was, my lord,
On
almost
merit?
on merit disposal, my lord. It was not said that, my lord, it is CRP is not maintainable. Under 226 to 227, I have filed, my lord. Thereafter, I have handed over the brief to my claim, to my advocate, my lord. He did not take any steps. In between, my lord, 5,000 something is delay. My lord, thereafter, I have in title appeal, my lord, while disposing the delay of condonation application, my lord, some, my lord, observation was there, my lord.
No, maybe, but now you first rectify your pleadings.
Please, I will rectify, my lord. In my lord, I will rectify, my lord, because therefore, my lord, I have to take a one certified copy or my lord, will give you a type copy, my lord. Because I have noted down the lines, my lord. Because I have to take certified copy of that, my
No,
lord.
certificate copy, record is before the High Court.
Record is
From
high
where you will get the certificate copy?
from this copy section, my lord.
Copy section.
Or lordship may permit, or lordship may, my lord, permit me to give a type copy on some by certified copy, my lord. I will certify to be true.
Okay, that will serve the purpose.
That will do, my lord, because I have.
Yes, 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 because the original record is available.
Record is there, man. I have already written the whole. Case, my lord.
Heard Mr. P.K. Bhunya, learned counsel for the appellant, then Mr. N. Hock, learned counsel for the respondent.
It is a, my lord, case of 2002. Ex parte decree was there and already execution has been over.
Execution?
My lord,
Decree satisfied. my lord.
decree satisfied, it is in
Decree
favor of
satisfied.
Decree
my
satisfied.
lord. In 2002, my lord, suit was decreed. In 2006, they have filed a petition under order 9 rule 13 after 4 years. Because there is delay, then High Court rejected that petition. Then but immediately they did not file the appeal. After 11 years, they have filed an appeal, a first appeal before the first appellate court. And there was delay of 15 years. And now, my lord, against that order, they have filed this second.
My lord, now in the, my lord, with
We
all,
have
with all
to
respect
dispose
my-
of this RSA.
My lord.
We have to.
with all respect to my senior, my lord, that lordship may formulate one substantial question of law. Whether the
No,
learned
first
part-
you rectify the.
Yes, definitely, my
rectify
lord.
the
By
pleadings,
next
and
day, I will
thereafter,
rectify. Whether the first appellate court is right. or
uh,
wrong.
It is submitted at the bar that one page of the impugn
Memo.
order is missing from the, no, is not available on the record. No, was not enclosed with the record. No, with the appeal petition. Mr. Bhuya, learned counsel for the appellant, submits that he will rectify the defect and press for granting him 1 week time.
My lord.
1 week time. Peer is accordingly allowed. Recessal is the matter after 1 week.
Kindly, what date may be fixed, my lord, kindly, my lord.
Third date?
Third of October, my another second appeal is fixed, my lord. Only
3rd of October.
Third of October.
3rd of October, okay.
It is before that or after the vacation, my lord.
Then after vacation.
Before vacation, my lord.
After vacation.
Before vacation, my lord, kindly, my lord.
First October.
First.
Okay.
I'm deeply obliged, my lord.